I'm Judge Sally Willett. I'm retired. I have 35 years on the bench. In 5 months, I will have had half century in Indian law. I'm also a former teacher. I have a master's and bachelor's in foreign languages and education. And I do a lot of teaching to Indian people, and always did. Even in my hearings, I always did 15 minutes of allotted land law explanation, because I realized I was the only point of contact for people to get that level of information. Now, what I'm going to tell you is that I don't know why people don't know this, because it's evident, but I guess I look at it dimensionally. APRA isn't a reform statute. It is an elimination system designed to carry out Department of Justice, Office of Personnel Management, and DOI's litigation strategy, which is to have no duties, to get rid of land cheaply, and to provide no services to allotted landowners. The goal was to be out of the allotted land business. This was in 2006 and 7, in 10 years. There's a letter to Brian Dorgan, who's chairman of the Senate Indian Affairs Committee, that says that. It was an attachment to a letter to him from the Secretary of Interior and the Attorney General of the United States, Alberto Gonzales, of the pompadour hairdo. I couldn't help myself on that. The political nature of APRA, American Indian Probate Reform Act, so-called, has blinded the drafters, who were amateurs dabbling in Indian affairs and Indian event, to the conspicuous defects in the inheritance system. The proposed changes that we're going to discuss today show that DOI doesn't know what it's doing in probate, that it has no institutional knowledge or memory sufficient to fix anything, and it doesn't understand due process of law, which is a constitutional amendment, and nor does it understand the limited role of the executive branch in drafting procedural regulations. Somehow there's a belief that they get to write law. Not so. I point this out to you to show you why APRA isn't a probate reform statute. There are 21 sections in Title I of the American Indian Probate Reform Act. Only one involves probate. That's Section 2206. It has several subsections, but the main ones are A, which is intestate or no will cases, and B, which is testate, which are will cases. It has a lot of bad stuff in it, and has had. For example, and we're going to come back to the transfers in a second. There's a disregard of law. There has been throughout, from the 2% rule to the 2000 ILCA amendments to APRA. I'm sorry, I hit the wrong button. I didn't intend to hit any button. In APRA, not content with the single heir rule, which in fact cures fractionation, Swimmer decided to have the statute written so it reached out and took heirs' interests. Spoiler alert, heirs don't have interests, they have expectancies. Had they read Hodel v. Irving, 1987, they would have known that, but clearly they did not look at that Supreme Court case involving Indian probate. In 2008, after having tried to devalue the entire allotted land based on account of fractionation in 2005, Swimmer went in and changed the definition of land to exclude appurtenance, fixtures, and permanent improvements, which are typically the most valuable incidents of land. Why did it do that? So that it could get Indian allotted interest cheaper under all the transfers. Another feature of APRA is that it knowingly uses bad data. The Indian Land Working Group and I, back in 2004, we told them they were using bad data, and we were told by the head staffer on the Senate Indian Affairs Committee that we have to strike a staff in the ground somewhere. Well, why don't they strike it at the point where legal vesting occurs, which is the date of death? Due to backlogs at BIA, at OHA, Land Titles and Records Office, the data is always bad. And once it's corrected, it relates back to the moment of death. So you basically have conflicted or clouded title on anything that is using a false starting point. Now let's look at what is a transfer. I just randomly put these up. Anything that moves property from one set of hands to another, I'm calling a transfer. You have fair market value acquisitions. You have tribal acquisition of non-Indian interests. You have secretarial acquisitions. You have probate purchase options. You have, that's voluntary. For sale of less than 5% interest, intestate, meaning no will. Tribal acquisitions of family farm interests if sold in less than 5 years after being received. Consolidation agreements in probate that no one is told that there is that opportunity. And then you have tribal statutory purchase options used as the federal standards for determining who gets what. These transactions, the reason for the lowballing of the value is so that the trustee can self-deal, get more bang for the buck in order to be out of the Indian business in 10 years. This is such a dirty pool that it almost doesn't, there's no ethics involved here. This is just simply wrong. I'm going to go back and give you some factoids that will put everything in context for you. There were millions of acres allotted by 1860. The General Allotment Act was passed in 1887, and the largest tracts were 160-acre tracts. We knew from the General Homestead Act of 1862 that 160-acre tracts were worthless, that you actually needed a 400-acre tract in order to have a successful family farm. So against evidence, counter evidence, General Allotment Act used the fail system. It is also to be noted that most of the allotments are located west of the 98th meridian. It's a point at which dry farming is not sustainable. Note the first line, millions of acres allotted, no probate authority until 1910. Why is that? Indians weren't expected to keep their land. It was going to be a self-acting wheel, according to Senator Henry Dawes, that once put on track, it would just fade into the future and Indians would eliminate themselves as a problem. We would like to think that the probate authority was for the benefit of Indians. It wasn't. It was written for the benefit of the non-Indians who acquired interests by various means from Indians, and they didn't feel secure about their title. No one was concerned whether Indians continued to own the interests or their ownership. Now, this is something, and I'm going to go down to the bottom box, the trustee has always sucked. If you want to say it in French, it's S-U-Q-U-E-D, at managing and probating allotments. In 1913, there was a 40,000 estate backlog, valued then at $60 million. And in today's dollars, that's almost $1.6 billion. This is what the trustee wasn't doing. The proposed changes fix none of the problems, really. They create new ones. There are 13 proposed changes that I'm going to go through in a minute, but before I do that, I want to go to the categories. I've categorized these into 7 groups. Now, because I speak Okie oil slick and I sometimes get off on homilies, I'm just going to tell you how I wrote them. There are proposals that exist because the trustee turned gold into lead and wants to go back to gold again. 4, 6, and 11 are examples. Proposals that reflect no understanding of existing authority. 7, 8, 10, and 13. They say they don't have authority to get medical records. Unbelievable. 3, proposals that are unconstitutional or require legislation because they're substantive legal changes. An example is not giving notice to small estates and given an opportunity to be heard till after the proceeding is concluded. 4, proposals that are strictly to make life easier for the trustee at the expense of the beneficiaries. And that, of course, the notice provision is merely one of them. 5, proposals that demonstrate no institutional memory or knowledge whatsoever. One of them says they need authority to probate off-reservation land. This is stunning. We always probated off-reservation allotments. I don't know why they quit or think they don't have the authority. All my group of judges from back in the Ice Age would be shocked that somebody said this. 6, there are proposals that are no-brainers, thumbs up, that were gold turned into lead, that need to go back to the old gold. And the last one is proposals that are so wild that they defy credulity. The not having authority to probate off-reservation lands is one of them. That and inability to obtain medical records. It is simply beyond belief that people are thinking this way, that demonstrating fully that they don't know what they're talking about. Now, here are the proposed changes. And I have a chart, excuse me, that I did so I could put up, but of course I can't find it. And this one makes me laugh. 25 USC section subsection A it is said contains a gap in intestate succession to situations. Well, first, you don't plug in substantive law and procedural regulations. That is not even legally authorized whatsoever. But in fact, in 2005, because I teach probate, I sent a chart to the Department of Interior showing them they didn't have 2, but 3 holes in their system. They were so busy with their political agenda and duty reducing ideology that they really weren't paying attention to what they were writing. Now, the probate purchase option is overly burdensome. Well, talk to Congress. You don't get to change that in procedural regulations. Look at the act and see how it's written. The procedures are the procedures because they're outlined in the act. So this is again a regulation versus statute situation. 3, the notice provision seeks to water down notice to parties in interest who are co-owners. Emphasis on the word parties in interest. If you look at the definition of parties in interest in APRA, in BIA's regulations, in that's good enough, you'll see that anybody who stands to take anything in the estate is an interested party. You can't cut out and not notice people who have an interest in the outcome. That's a violation of Mullane versus Central Hanover Bank, a 1950 case that is the seminal case on due process, and Goldberg versus Kelly, which is a 1970 case that said you can't alter someone's substantive rights without notifying them in advance. Now, limiting payment of funeral and burial expenses. This is a gold into lead, now going back to gold. There was never any reason for changing. Oh, excuse me, I hit that wrong. There was never any reason for changing this. This was part of the DOI, DOJ, and OMB's desire to quit doing stuff and not leaving IIM accounts open. We always paid them. I even got a standard full service funeral cost for the Rocky Mountain area, and I would pre-authorize with the superintendent a release of half the funds in advance up to the maximum amount of the full service funeral. We didn't have an amount that had to be in there because we had general claims and we had preferred claims. General claims had a 3-year life, preferred claims had a 7-year life, and the judges had authority to prioritize them. They need to go back to the old 43 CFR 4.251 and 4.253 regulations. The tribal purchase option from non-indents needs regulations. Do they not know that there are 5 statutes with tribal interests in them? Let me see if I've got this right. You have, who's the first one? I'm always bad on this. You've got Yakima, you've got Warm Springs, you've got Nez Perce, you've got Standing Rock, and you've got Lake Traverse. They already have this system. All they need to do is add a few words in the statutes, and then you can implement regulations. Inventory corrections are too cumbersome. That's the gold into lead into gold. Here's how it used to be. If you had a typo or something, Land Titles and Records simply corrected it, sent out the administrative correction. And if you were going to reduce the share size, for example, if there was an error, a 1/2 interest was actually supposed to be a 1/20th, an order was it was prepared by Land Titles and Records and sent to the judge for signature. That's the old system. They need to go back to it. The only reason it was changed was because people were tinkering just to tinker. This happened after the high-level implementation plan in the implementation phase, and there were not particularly knowledgeable people on that in that group. Now, the proposal to create medical records demonstrates a paucity of subject matter knowledge that is so profound, it is shocking. 25 U.S.C. Section 374 authorizes the administrative law judge to issue subpoenas. I used this authority to get medical records, and I made them a subpoena duces tecum. That means you should bring the records. The U.S. attorney enforces those. It's difficult to get them to do it because they don't place high value on this process, but you still push to get it. You can get them, and only the judge can get them. Why they don't know this is authority, it's in 25 United States Code. I do not know why people do not know this is here. Status determinations, this was bewildering. You have the American Indian Probate Reform Act. I suggest that everyone do a keyword search in that act and find out how many times the word Indian for eligibility purposes or eligible heir or lineal descendants are used. It would be simpler for them to simply identify the case or cases in which they think it is not required. Under no set of circumstances should any official in the Department of Interior have an open-ended ability not to determine key ingredients of inheritance and eligibility therefore. Number 9, the proposal to expand the points at which disclaimers may be accepted. Oh, hello, gold into lead to gold again. This was never a problem. And now I'm not even sure I'm sorry, I did that again, that there's a situation in which it can't when it goes to fee. There are a variety of circumstances, but let me get down to this. I think what they've got confused is that the Indian Reorganization Act, well, I'm not going to go into that. Let me backtrack. We accepted disclaimers whenever we could get them because property could go out of trust. We sent them disclaimer forms if we saw a non-Indian with a notice of hearing. They came to the hearing, we re-explained what was in the notice and gave them another form with a self-addressed stamped envelope to return the form to the judge. I did not accept them at the hearing, even though hearing was supposed to be the last time they could file, which you can always hold a supplemental hearing and it extends it. The reason why we did that was the consequences were so bad because typically the non-Indian had Indian children. And if they believed that it went from an Indian to a non-Indian and automatically flipped back into trust for the Indian kids, we explained to them that that was simply not the case and that getting property back into trust was extraordinarily difficult. So I only had, out of the thousands of cases I adjudicated, I only had 5 people who did, non-Indians who didn't explain, and there were specific reasons in each of those cases. I can tell you, children or parents do not cut off the trust status of their children easily. Let's go to 10. This is right up with the medical records. Difficulty finding evidence in presumption of death cases makes the process easier. Where to begin? Difficulty finding evidence. Hello? Presumption of death cases occur because there is no evidence of death. This one just was like a moonshot past my ears. What they're describing as a presumption of death is the idiotic missing heir provision that Indian Land Working Group fought against it with the Senate Indian Affairs Committee prime staffer in Albuquerque before April was enacted, saying that they're not missing and they're not dead. You're not looking for them. They have a threshold for estate value that they won't engage in electronic searches. And the values on the inventories were made up and they were extraordinarily old. So they were using their own negligence in order to call people dead, terminate legal existence, and transfer their property to third parties. Rehearing and reopening, this is like the funeral expenses. 43 CFR section 4.241 and 4.242 were gold. They were the best rehearing and reopening regulations. When trust reform went into the implementation phase after the high-level implementation plan, they got in there, the same group of people that wiped out funeral expenses, they got in there and they basically collapsed the difference between rehearing and reopening and making it standardless. Go back to 43 CFR section 4.241 and 4.242. In the event, I just realized, in the event that I used those statutes, or correction, regulations for funeral expenses, they are 4.251 and 4.252. I'm making that correction now. Expand the scope of small estates and make a decision on the record and give parties an interest an opportunity to comment afterwards. Mullane versus Central Hanover Bank, Goldberg versus Kelly. This is unconstitutional. And I would like to read, I put it in the other PowerPoint for right-of-ways. The March 12th, 2021 decision vacating Tara Sweeney's decision to lowball the Fort Berthold landowners basically says the Department of Interior is going to give Indians due process. So this has got to go. I don't have any problem with it expanding estates up to a limit of $5,000, but I sure do have a problem with violating the Constitution again, as they did with the 2% rule. Now, this one goes into category 7, bar none. Expand jurisdiction to cover off-reservation allotments. When did it go away? All the judges, at least that started out with OHA, I had all kinds of off-reservation allotments in my own territory and probated them with abandon. I even had transfer cases from North Dakota and Montana that had off-reservation allotments, had off-reservation, or correction, no, that was trust, correction. I'm going to just stick with the Montana, North Dakota. Northern California has a lot of off-reservation allotments, and the Department of Interior has been trying to get rid of them. I'm thinking they have confused their own efforts to maul the off-reservation allotments in California with suddenly deciding they don't have ability to address them in probate. They do, always have. Why they don't now, they're going to have to figure out. Now, I decided, instead of chewing on the edges of amateurs' proposals, that I was going to lay out a system that would address what I saw as the need. And that's based on adjudicating thousands of probate cases and actually teaching Indian estate planning in each one of them. First, I'd fix the system, depoliticize it, which is really what primarily what's wrong with the system. I'd give it adequate resources. In 1995, Indians were funded at 25%. BIA was funded at 25% of need. Who knows what OHA is funded at? They used to steal our money all the time for the rest of the department and for the rest of OHA. You need to give due process, and you have to have cultural sensitivity, not cultural imperialism, and you had to have maximum adjudicative protections. I worked in an agency that really denigrated Indian work, and it was offensive to me, very offensive. And I was actually told that I was not viewed as a team player, to which I responded, my team's red. If there's another team, I don't want to know about it. So therefore, you see why I was popular. Is that Okie oil slick talking? I don't do that on purpose. It is, excuse me, it is who I am. I speak this way. And I'm being quite constrained in this presentation, I will tell you. Also, you need to simplify and decrease the burden. We needed a uniform probate code. I didn't say an Orwellian out-of-body experience that APRA is. You needed to limit inheritance, but you had to do so fairly. You needed to eliminate non-Indian inheritance of title, but you didn't need to give 100% life estate to Missy Hot Stuff, the trophy wife, and who's probably older than the kids. You have to maximize knowledge and data availability, which I've done my entire adjudicative career. I not only give sessions for government agencies, for tribes, landowners, and families. I do that on my own time. I am a resource available to folks. And I know a lot of stuff. Not because I'm brilliant, it's because I'm old. And over time, that's why Indians respect elders. Over time, you build up a fund of knowledge. Now, you needed dollars for consolidation and acquisition. The first thing I would like to point out, think of the 2% rule. The first thing I'd like to point out is the cost of the 2% rule. From 1983 till 1987, they were going back and doing the income calculation or the income for different periods in order to apply the 2% rule to two versions of the act that was held unconstitutional. We told the drafters, I knew the drafters. I'd been a law clerk with one of them, and the other one worked across the hall when I was in Maine Interior. I knew them, and I knew what they didn't know. They didn't know probate, and they did not know allotted land law. But nonetheless, they wanted to get something on the books. And I said that you can get something on the books, but unconstitutional isn't going to stay long. So basically, what you have to do, this can't be a 10-year fix in and out. It took from our system from 1887 until now to get to this point. Anybody that thinks that problem's going to be fixed overnight is delusional. Moving on. This is the system. This is shocking to most people. This is the system. I notice my cursor moving around. This is the system that I started out with. We could go back this far. I only actually went up to 3 or 4, I don't remember, but in this range in terms of probating. And when we did, the state laws we were applying in the old system usually had an ancestral property rule where this was required. That no longer exists under APRA, and it didn't exist under ILCA 2000, which was never certified or used. But the entirety of this system is what the old system looked like. The 1 and 2s and the down through 3, ignore the 4, are the APRA system. But here's the dirty trick. For the single heir rule and the for sale rule, parents and siblings are not entitled to inherit. And there was a reason for that. First of all, in order to inherit as a single heir rule or the single heir rule, you had to be Indian or an eligible heir. The least likely person to be Indian or eligible heir were the lineal descendants. That is one of the reasons why they knocked off the ancestors and the collaterals. The other is the decedent inherited most likely at the same time, so that if the decedent's interest went to one of the co-inheritors, it would increase their share size and foil the desire to get out of the Indian business cheaply. So if the people, the oldest child, oldest grandchild, oldest great-grandchild under the single heir rule do not qualify as Indian or eligible heir, it fast tracks to the tribe. That is why. And also I would point out that on April 21st, 2005, Russ Swimmer, bless his pea-picking little heart, and the long-term acting Asia, Jim Kaysen, with an incredibly vermilion face, they abolished statutory willmaking by an administrative memo and told Indian country that it was in their best interests. mean, that didn't even pass the laugh test. Neither of them knew squat about probate. Swimmer's only knowledge was east side of Oklahoma, which are termination laws. I know because that's where our land is located. Now, Kevin Gover has a great term. He describes these people who are writing these laws that have no long-term experience as amateurs who dabble in Indian affairs. And he's correct. John Collier, the legendary commissioner during the period of the Reorganization Act, called them experts in vacuo, meaning experts in a vacuum. 6 of one, half a dozen of the other. Now, this is something that I would like to emphasize. Most people don't really get this. Probate is a subspecialty of Indian law. The Arizona treats it as a subspecialty. You can't even get the Native American Bar Association people to will make. I tried under APRA because they're afraid they're going to be found guilty of malpractice and then subjected to sanctions. Yet we have people just bobbling off and just writing stuff. You know, I may fly airplanes, but I don't write laws that pertain to thermodynamics or aerodynamics. I'm not going to explain this to you, but I'm going to ask you to look up the Dunn-Kruger effect, because that is basically what's going on, and it's terminal Dunn-Kruger effect. That is your homework assignment from this presentation. Now, back to my cartoons. Sometimes instead of crying, I just make fun of people. And in this one, this is the 83-84 2% rule. This is what the government was doing to Indian landowners. This is ILCA 2000. My God. I always thought if that guy thought the way he writes, I couldn't even imagine his processes. He wasn't evil. He was really enthusiastic, tragically. I told him he should write simple declarative sentences with non-complex, non-detailed instructions. And he said, that's okay, BI can tell him what it means. And I said, God couldn't tell them what it means. I think that was a moonshot over his head. Now, here's April 2000, the less than 5% for sale. I was on that work group. Oh, by the way, I've analyzed every piece of so-called reform probate legislation since 1981 and all the regulations. I've been on most of the work groups, and I can tell you without fear of contradiction, nobody listens to anything substantive. They have a political agenda. They go with the political agenda and give you the finger. Oh, I shouldn't have said that. Too bad. So let me tell you about how the for sale rule came about. I was on the work group. We were on a telephone conference call with the Senate Indian Affairs Committee primary staffer, and we had already been told we couldn't make any changes. And then he told us about Russ Swimmer's baby, that he wanted to go after less than 5% interest in testate. It had never been discussed. It had never been mentioned. The single heir rule had. It's called primogeniture in another life, but for sale was not discussed. It was imposed. At that point, I hung up the phone and discontinued association with that work group because I would not be associated with such a foul deed. I could not do that and maintain any sense of personal conscience. Now, this is my interpretation of 5% rule. We have Swimmer and we have Kaysen. And we notice the Indians are being hit over the head by the supposed trustees. My thought is stop landowner abuse, follow the law. They don't even know what the law is. They don't look, quite obviously. Now, anytime a system is difficult, the first thing I do is I try to conceptualize it, because I teach this and I want people to understand the concepts. They don't require memorization. I repeat it enough and go through it enough and give them their manuals so that they will be able to find everything that they need in my classes. Think of the acronym PAPI: Plans, Acquisitions, Probate Codes, Inheritance, PAPI. This is the original ILCA system in 83 and 84. It has not changed. Everything that has been added on in 2000 or in 2004 or thereafter goes in one of these boxes or appended to one of these boxes. So when you want to think of APRA, think of it through this visual. Now, I don't have anything left to tell you. I realize this was a blast through, except one line from my favorite boy, Will Rogers. He said, if it weren't for reformers, Indians wouldn't need saving. Go, Will. With that, I'll conclude.